Okay, what's the Age Discrimination in Employment Act, or the ADEA? Well, this is an anti-discrimination act that runs parallel to Title VII, so it's separate from Title VII. But what it says is that an employer that has 20 or more employees, okay, cannot discriminate against an employee based on age. Now, there's a line there. It only applies to employees 40 years old or older. So conversely, an employer can discriminate against an employee or can use age as a factor for hiring or other employment decisions if the employee is under 40 years old. Okay. So that's where it applies. Now, it's a little bit different than Title VII. As we talked about under Title VII, an employee can bring an action based upon discrimination, and the employer can defend against that action by showing a bona fide occupational qualification or business necessity. Now, under the Age Discrimination and Employment Act, the employer doesn't need to show that. Basically, they simply need to show that the basis for some discrimination or disparate treatment of the employee was based on a factor other than age. Okay, age can be a factor in there as well, but if the primary reason for treating an employee different was not age, it was some other factor, then that is a defense. And then the employee cannot rebut the defense by showing that there was a less discriminatory manner. So that as well is different from the Title VII rules. Okay, so under the ADA, there are really three remedies. You can ask for reinstatement, lost wages, and then sometimes you can get additional consequential damages for trauma. Okay, now if the employer willfully violated the ADA, they were aware of it and they did it on purpose, there is a statutory remedy of double damages. So whatever the actual damages are times two. But that's limited as well, especially when the state is the employer and you bring the action against the state. There is no action for money damages against the state. So those are the general limitations there under the ADEA.